so much, Jonathan, and thank you, Cindy, and everybody at Cooper and Anna for organizing this. But most of all, thank you to all of the tenants joining tonight for all the work you do organizing and keeping the tenant movement going and improving our communities for all of us. My name is Mike Grinthal. I am a tenant lawyer at an organization called TakeRoot Justice. TakeRoot Justice is a nonprofit legal services provider that works with people who are organizing to have the power to change the laws and policies that affect our communities. I've gotten to meet a lot of you, though I do see some names here that I haven't met before, and that's really exciting. I'm going to share my screen. There we go. And moment. Go. So our topic tonight is SLAPP suits. SLAPP, SLAPP, stands for Strategic Lawsuit Against Public Participation. So what that is when you are organizing, when you're participating in public processes, and somebody who's got the money and the power starts a lawsuit. Not necessarily because the lawsuit has merit, but because it's a good way to bog us down and prevent us, make it too expensive for us to continue organizing. So tonight we're going to talk about what are common bases for SLAPP suits in tenant organizing, how we can reduce the risk of having lawsuits aimed at us, and how the New York anti-SLAPP law works so that if we do face a SLAPP suit, we have ways to fight back. Before I start, I do just want to say I'm going to be talking a lot tonight about what the law says we should and shouldn't do, right? It says we shouldn't say things like this, we should say them this way, we shouldn't say this kind of thing. That's not the same as saying you shouldn't do that, right? Sometimes we have to take risks. Sometimes we have to tell the truth, even though we know it's risky, right? Everybody on this call makes those kinds of decisions every time you organize, and we make them together. So some decisions might be legally riskier than others, that doesn't necessarily mean you shouldn't do them. But my job is to make sure that whatever decisions you make, you know what the consequences will be and how to keep the risk as low as possible. Right. So first, we're going to be talking a lot tonight about speech. So let's lay out some very basic facts about speech. In the United States and in New York State, we have large and robust protections for freedom of speech. As I'm sure you're aware, the United States Constitution and the New York State Constitution give us the legal right to engage in public affairs, government and civic affairs, speak on public issues, petition government officials, write letters to the editor, speak to the media, circulate petitions, make complaints to the government, put up signs, circulate letters, flyers, all of these things. These are all protected activities. But there are some areas that legal freedom of speech doesn't protect us on. So the First Amendment does not cover, for example, when we sign away our right to say something, like when we sign a confidentiality agreement in a lawsuit. The First Amendment doesn't protect threats. It doesn't protect defamation. It doesn't protect tortious interference with contract. I'm going to guess that the first of those three things are things you've heard of and can tell what they mean. And the fourth one, tortious interference with contract, sounds like a thing that I just made up. We are going to get into that, and we're going to talk about what that is, as well as defamation. So just put a bracket around the tortious interference with contract. We'll come back to it, but for now, let's talk about what defamation is, because defamation is something that if we do it, can make us vulnerable to being sued by the person or the corporation or the group that we're talking about. Right? So what is defamation legally? It means that you published, and here in the law, published just means you said or you wrote. You shared a statement with at least one other person. So this doesn't mean, you put it in a book or a newspaper. It just means you shared it with a third person, not the person you're talking about. It could be one single person that you talk to. It could be what we talk about here in this meeting. It could be what you talk about with your neighbors, right? As long as you're sharing a statement with somebody else who is not the person you're talking about. And that statement is both false and harmful. So it's a bad statement that causes the person you're talking about injury, right? It hurts their reputation, or it makes people not want to do business with them, or it gets them in trouble. And it must be false, right? A true statement can never be defamation. So defamation is when you talk about somebody or some group to somebody else, and you say something that is harmful to them, and it's false. Oops. Let me see if I can go back there. There we go. There's two forms of defamation. You've probably heard both libel and slander. Libel is when the statements that you make are in writing. And that can be formal. It can be, a newspaper article or a book, but it can also be informal. It could be a text message. It could be a tweet. It could be, a Facebook post. Slander is when you make the statements out loud, right? So you say them to another person. It can be something that is broadcast through radio or TV or something, you say in a recording that goes online, or it can just be something you say to some other people without any kind of recording. The difference between libel and slander is simply that libel is in writing, slander is out loud. Other than that, the law is exactly the same for both, and the definition is exactly the same for both. So in general, we don't want to find ourselves in a position where somebody can sue us for defamation. At the same time, we want to be able to speak and we want to be able to say unpleasant truths, and we want to be able to criticize landlords, elected officials, corporations, etc. So how can we do that while trying to stay as safe as possible against backlash? I mean, the simplest way to keep ourselves safe from defamation charges, claims, is just to make sure that everything we say is true, which is something we should be doing anyway. And the fact is, we know that the truth is enough. We know that landlords harass and break the law. We know that corporations spend money to gentrify and drive people out, right? The truth is in fact on our side. And we don't, telling the truth is enough. However, when it comes to legal process, when it comes to courts, it's never a matter of just what's true, it's what you can prove with evidence. So if you imagine that you're being sued, you've said something about the landlord, it's true, but the landlord is suing you and you can't prove that it's true, you could be in danger of getting bogged down, of having to pay damages, of getting distracted and not being able to go about the organizing campaign. So the safest kinds of statements, and again, we don't always have to be safe, right? Sometimes we have to take risks, and sometimes we know things are true even though we don't have documentary proof of them. But just in terms of evaluating the risk of saying any particular thing, right? The safest things to say are where you have data or evidence backing up the statement. Like you say, our experience shows that when this landlord buys a building, he evicts 15 to 20 rent stabilized tenants. And we can back that up because we have documentation from the courts, we have the results of investigations by state agencies. We can back it up if we were sued, right? When there's been a violation placed, so that if we say, there's mold in my bathroom and the landlord has done nothing about it for 3 years, and we actually have violations placed by HPD, that's pretty safe, right? Or the landlord has performed illegal construction, and in fact, there's a violation that was placed by Department of Buildings for illegal construction, right? When there's been a finding in court, right? Once somebody goes to court and has a dispute over a fact and the court makes a finding, they're stuck with that, right? So if we say this landlord has a long history of harassing tenants, and in fact, that person has signed an in-court settlement admitting that they did it, um, if we go to court with them, they're stuck with what the court said in the past or what they signed in the past. They can't reopen it, right? Which is why newspapers, when they write about crimes, they say the alleged killer, right up until there's a conviction, at which point they just start saying killer. Hopefully, that's not the kind of fact that we're going to have to talk about. But, um, you know, newspapers will say, the landlord allegedly harassed the tenant. But if we get a court decision that says there was harassment, we don't have to dance around it anymore. And of course, when you're actually just referring to something that the party said about themselves, right? That doesn't necessarily mean something that they broadcast about themselves. It may be something they thought they were keeping secret, like internal financial documents or uh, confidential contracts that they sign that somehow get leaked or become public. Um, and there, even if it turns out that the thing we're saying is not true, uh, if we're repeating something that they said about themselves, they can't sue for defamation, right? They can't say, I'm suing you because you're repeating the falsehood that I told you about myself. So when we're quoting somebody else, we don't need to worry about defamation. So here's some examples of statements that if we said them to the media or we said them at a rally would be risky, and ways that we can try to make them safer without um, compromising the truth of our message. Okay. So, for example, if we say this landlord is neglecting repairs on purpose because he wants to drive out all the rent stabilized tenants and renovate the building, that's a risky thing to say because we're saying the landlord has this intent. The landlord is doing this on purpose and has this plan. Uh, and that's going to be a very hard thing for us to prove if we're pushed to it. We may know it's true. Everybody may know it's true. But if we were in court, we couldn't prove what's in their head. So we might rephrase that to say, well, while I'm not a mind reader, this landlord is doing all the things that you would do if you wanted to drive out all the rent stabilized tenants. Right? So there's often ways we can just rephrase what we're saying so that we're still getting the same message across, we're still getting the same truth across, but we are not as at risk for the landlord to come back at us and embroil us in a lawsuit, right? We say this harassing gentrifying corporation is making my life miserable, right? We're accusing a corporation of harassment. And that's a factual statement. We're saying they've done harassment, which is a legal thing. And we could be in trouble if we can't prove that that's what's happening. On the other hand, if we've had a finding of harassment by a court or by DHCR, then we're safe. It's safe to say, right? I've been breathing in a lot of dangerous toxins and mold spores at the building. Again, that may be something that we strongly suspect. It may be something we can tell from the effect it's having on us. But if a landlord sued us and said, you're falsely accusing us of having toxins in the air, and we don't have any evidence of it, we could be in trouble, right? On the other hand, if we have HPD violations for lead dust or mold, we would win that case. We would win that defamation case. Um, instead of saying this corporation is the worst in the city, you say this corporation is one of the worst, right? A lot of this, I'm sure you can work out for yourself. It's somewhat intuitive. Sometimes we're just hedging. Um, you know, our job as lawyers is to work with Cooper Square and work with all of you to make sure that you can say what you need to say in public and get your message across with as little risk as possible. So if you're not sure about whether something might be legally risky to say or might, make you vulnerable to a backlash from the landlord, reach out to Cooper Square and they'll reach out to us and we can not only take a look at it, but we're never going to say, yeah, that's risky. You can't say that. We're going to work with you to try to figure out a way to say it as plainly and as clearly and with as much impact as you planned, while at the same time mitigating the risk. And often we can figure out ways to do that. This is an actual example from Cooper Square's history. Some folks may remember this. So tenants write a flyer for an event in Union Square saying dirt bags for, actually, that should say dirt bags for dirt bags. And the tenants are going to be bringing bags of construction debris from their buildings to the doorstep of the office of the landlord that's been doing all that construction as harassment, right? The flyer says we're coming together to push back against two bad acting landlords who use construction as harassment against tenants. It also says we'll deliver a reminder of the damage caused by illegal construction and displacement to two of the city's most aggressive landlords. But the flyer doesn't name the landlords. So here I want to open it up to all of you. Based on what we've just talked about, what do you think of this flyer? Is there anything in here that strikes you as maybe risky to say? Are there things in here that strike you as safe to say? And what and why? For example, what do people think about the statement that says we're coming together to push back against bad acting landlords who use construction as harassment against tenants? What do you think? Is that a safe thing to say? Is that risky? Feel free to unmute and say it, or if you're in a place where you're not able to unmute, drop it in the chat.
Hi, I
Hi.
I wanted to just give my opinion. I think it's fine. I don't see anybody being named, and they're talking about somebody's bad practices, and there may be talking about things that they're doing that shouldn't be or that are illegal, but they're not necessarily calling them out or specifying.
So sorry, Manny, I think you got cut off there at the end, but you heard most of it. So your take is this looks safe. You mentioned because it doesn't name the landlords, and because it's naming things that they're doing. So that's a good start. Um, Supposing that at this point there are no Department of Buildings violations on record, and though the tenants have brought a harassment case against the landlords in housing court, the case hasn't yet moved forward and there's no findings. And I see in chat, um, Virginia suggests that we say, instead of saying who are using construction as harassment, try writing tenants say there's being used, they're using construction as harassment. So instead of saying this is true, instead say, this is what people are saying. What do we think about that? People think that would help mitigate the risk? So I'll give my answer as a lawyer. I think it makes it a little bit safer because we can say, oh, this is what people are saying. On the other hand, we're kind of just quoting ourselves. So it may not be enough to shield us. Somebody reading that flyer might reasonably read it as just, we're the ones saying they're doing construction as harassment. Let's see what else. We've got some other content in the chat from Alicia.
Oh no.
The language used at the top is not safe because of the vulgar rhetoric. What do people think about that? So that may be, I know there's the A word at the top, and we're also calling landlords dirt bags. Does using vulgar rhetoric, could that put us at risk of a defamation claim?
I guess if you were saying that they are dirt bags, but you're actually saying dirt bags for landlords, technically.
Yeah.
I mean, that's how I'm reading it.
Supposing, I know, in fact, the example from a few years ago that this is based on, I think the flyer, Cooper folks, correct me if I'm wrong, I think that flyer did actually say dirt bags for dirt bags. So if we assume we are, calling landlords that name, what do we think? Is that defamation?
Probably.
Okay.
And
What do
wouldn't
other
you
people
have to
think?
name the actual landlord?
So that is one thing. The flyer by itself would not be defamation, but considering that we are going to, in the future, reveal the names of the landlords, then those statements work together. And then we've got the names of the landlords and this flyer saying these are the things we're saying about the landlords. So holding back, right, not putting the name of the landlord in the flyer or in the statement doesn't necessarily protect us, because defamation can be done by a combination of different statements, right? If I say today my landlord, is an arsonist, and then tomorrow I say, by the way, my landlord is, John Smith. Together, that would probably count as defamation. So actually, the vulgar language does not put us at risk of a defamation claim. In fact, it's the opposite. And the reason is that in order for something to be defamation, it has to be false, which means the statement has to be the kind of statement that's either true or false, right? So if I say my landlord is deliberately using construction as harassment, that could be true or it could be false. If I say my landlord is a jerk, that's really just a statement of my opinion. I don't like them, right? That's not the kind of thing that they could prove false. So if I say my landlord's a dirtbag, it's insulting for sure, but it can't be a lie because it doesn't really have a specific meaning, right? You couldn't say like the objective definition of dirtbag is someone who does the following things and I haven't done the following things, so you're lying. So we're actually safe to the extent that we're, using strong language, to say this is how we feel about somebody. As Aaron says in the chat, a term of art. I like that. See, people also made some other suggestions for how we might make the language safer for us. Construction that is dangerous to tenants or illegal construction is kind of a narrower thing to say. Instead of construction as harassment, if we're not sure that we could prove what the landlord's motivation is. Yeah. Lydia points out, yes, it all depends on whether we have a finding already about whether these things are true. And he says, appear to be using construction as harassment. And I think that can be a fruitful way to go, especially when we say, listen, we're not going to draw your conclusions for you, but here's what we're seeing and hearing in our building. Can actually be a very powerful way of saying something because the audience will probably draw the conclusion that the landlord is harassing us. But we haven't actually come out and said it. So it's not, we're not liable for it. There are, I'm sure we could come up with a lot of other ways that we could play with this language, that we could workshop it together to make it less legally risky without taking out any of the force of it, without taking out any of the message of it. So that's really the most important takeaway here is we should never let the threat of a SLAPP suit, the threat of a defamation suit, shut us up or keep us from saying things that are important to say, right? We may want to spend some time figuring out how to be as precise as we can so that we don't say anything that we can't defend. My experience has been that when we do that, we often come out with language that's even more powerful than our first impulse. So if you're curious or if you remember, if you were around some years ago, when that flyer actually went out, Cooper Square Committee did get a cease and desist letter from one of the landlord's lawyers, insisting that they cancel the protest, and that they stop calling the landlords dirtbags, neither of which Cooper Square stopped because those things are perfectly legal. They also accused Cooper Square of defamation in saying that the landlord is one of the most aggressive landlords in the city and is a bad actor, and that they're doing construction as harassment, right? They said, my client has never harassed tenants and is vigilant about protecting tenant safety, etc. I won't go into the details of what Cooper Square's response was, in part because I don't remember all of it, but I do remember having a pretty involved conversation where we looked at all the different pieces of the flyer and all the different pieces of the action to figure out if any of them were dangerous and which ones we could lean on. And Cooper Square did go ahead with the action, correct me if I'm wrong, organizers, but I think changed some of the language. Okay, so we already gone over that. So as we talked about, poster advertising the march didn't state the name of the aggressive landlords, but because Cooper Square named them later and the flyer could be read together with what you say later, that can be defamation. Again, in deciding whether something is defamation, a court doesn't just look at a single statement. They look at everything you've said. Is dirtbag defamatory? Not necessarily. It's really kind of an insult. And, frankly, I'd be hard pressed to say exactly what I was accusing somebody of other than being unpleasant. Or, not even that. If I call someone a dirtbag, I'm really just kind of saying that I don't like them. And I'm also taunting them. Is the statement that tenants will protest damage caused by illegal construction and displacement to two of the city's most aggressive landlords defamatory? A number of people pointed this out loud or in the chat. This depends on what kind of evidence we have, what's in the house, what violations have been placed, what courts have said. All right. So we're going to have a time for questions and answers at the end. So if folks have questions about defamation, hold on to those until the end. We're going to shift gears now. We're going to talk about the other area where we've seen that it's not uncommon for landlords or corporations to push back. And that's this tortious interference with a contract. So the word tortious just means it's a tort, right? In law, a tort means something you did wrong to somebody else that you could get sued for. So what this means is you've interfered with somebody else's contract in a way that hurt them and they could sue you for. And this is how that works. There's actually two different kinds of legal claim for tortious interference with a contract, right? One is where you take an action that basically sabotages somebody's prospective contract. Somebody's working on getting a business relationship going, right? They're trying to recruit a tenant, they're trying to sell something, they're trying to sign someone up as a client, right? They're hoping to get a contract. And there's a prospective business relationship with a party, right? I know about that possibility, and I do something that intentionally interferes with it, right? Tend to block it, make it not happen. That by itself is not a legal problem, but it is if I did so acting out of malice or using wrongful means. And then finally, it has to have actually worked, right? If I try it and it doesn't work, no harm, no foul. You can't sue somebody if you didn't get hurt. So you're probably noticing that the key thing there is the wrongful means, right? In fact, trying to interfere with other people's contracts and make them not happen is what people do every day in business, right? So, if Jonathan is trying to sign up Laura as a client for his business, and I go to Laura and I say, don't sign with Jonathan. I'll give you a much better price and better service. And she says, sounds good. I'll sign up with Grinthal and not Jonathan. This is not a tort. This is actually just business, right? It could become illegal. It could become a tort, a legal wrong, if in fact I go to Laura and I lie about Jonathan. I say, Jonathan's got a long, his company has a long history of shoddy services and bad products. And that's not really true, right? Then I've done something illegal. Or if I go to Laura and say, that's a nice company you got there, would be a shame if something happened to it. And the best way for something not to happen to would be to sign a contract with me and not Jonathan, right? So threats or extortion, right? So if I use wrongful means to try to scuttle this contract, right, then I may have done a tort and I might be able to get sued. And in a couple slides, we're actually going to look at where this kind of thing might come up in our organizing in the tenant movement, because it might not be immediately obvious. Some of you might be thinking of examples already, but at first I want to talk about the other kind of tortious interference, which is where there's already a contract, right? Jonathan already has a contract with Laura, right? He's manufacturing widgets to sell to Laura's company, right? And that contract's already going on. They have an agreement. He's supposed to manufacture a certain number of widgets. She's going to pay him a certain amount of money. I know this. I go in and I say, Laura, I think you should ditch that contract. Break that contract and sign with me. And she says, I will. There, even if I don't use wrongful means, there, Jonathan might have a legal claim. And the reason is I've tried to get her to actually break a contract, right? I've actually encouraged her to do something that violated the contract. Okay. So tortious interference means either sabotaging a contract that's in the makings, that's in the works, by doing something shady, something wrong, or I blow up a contract that already exists by basically like getting somebody to spike the contract, to break the contract. All well and good. What does this have to do with organizing? So here are some examples where organizers and tenants have been accused of tortious interference with a contract, right? Community members write to a bank or a lender saying, don't lend to this landlord, right? They're a bad actor and we don't want you to lend money to them because they use the money to buy buildings and drive out tenants, right? That might be tortious interference with contract if we're not telling the truth, right? Or if we say something like, if your bank doesn't want trouble, you shouldn't lend to this landlord, right? So if we're edging beyond just saying, listen, we want to, for moral reasons, urge you not to lend to this landlord, that's fine, right? There's no claim there. We're entitled, we have freedom of speech to, approach anybody we want and tell them what we think they ought to do, right? And what's right or wrong. But if we cross the line into falsehoods or threats or, trying to trick people, then that might be tortious interference with a contract because this landlord is trying to get a contract, a mortgage with the bank. Right? So we've got a contract in the works. We go in, we try to stop it from happening, and we use shady tactics to do it. So again, if we just say, listen, like we live in the community and we want to urge you, right, to take the high road and not loan to this landlord, not tortious interference. If we go in and we say, if you lend to this landlord, people are going to get mad. And when people get mad, banks get bricks thrown through their windows, just saying. That's probably tortious interference with contract. Also a crime, but that's another training. Another example could be we protest outside a bank or a lender's office to prevent them from lending. So again, it depends how our protest plays out, right? If we march up and down in front with signs making our case, saying like banks should lend money to things that are good for the community and not things that we don't like, that's probably fine, right? If something about our protest crosses a line to the point where you know, we're acting in a way that's threatening to the people inside the office, and making them feel like, you know, they'll actually be in danger if they loan to this landlord, that would be tortious interference with contract. And one of the things you may be noticing here is that these are kind of blurry lines. A lot of this is like subjective, right? If we're asking the question, you know, we did a protest in front of a bank, was it, you know, just a protest and we were making our case, or was it physically threatening? That may be hard to say, and it may be, you know, it may come off differently to different, depending on where you stand. And so, you know, these things can be hard to predict. And that's why before we use these tactics, it's important for us to sit down and make sure that we're being as intentional as possible, that we've thought about all the different ways it could come off, and we're prepared to take responsibility for those things, right? Again, that doesn't mean we don't do things that are risky. Sometimes we do. I don't think there's a way to organize without some risk, but we should know exactly what risks we're taking. Here's another example of tortious that could be tortious interference contract. You know, your landlord is showing a vacant apartment to prospective tenants, right? And when they come in, the tenant association stands in the lobby and gives, you know, and says, "Hi, you know, here's a flyer about what's going on in this building and the history." And as a result, the person says, well, okay, forget it. I'm not going to rent here. Could be tortious interference with contract, depending on what's in those flyers. If we're simply handing out something that says, here's a printout of all the HPD violations in this building, then we're exercising our right to free speech. We're simply saying what's true, and we can do that, right? If we're handing out flyers saying, if you rent in this building, everybody here is going to hate you and you'll never be safe and you'll be shunned because we'll see you as a traitor, then that's probably tortious interference with contract, right? And again, you know, whether we're simply, you know, making our case or whether we're like coercing or applying pressure or threatening may differ depending on where you stand and who's looking at it, right? Here is an example that is not tortious interference with contract, but I've seen landlords claim over and over that it is. And I've seen their lawyers send us cease and desist letters saying this is tortious interference with contract. It is not tortious interference with contract to contact the landlord's bank and say, this landlord is in default. They're breaching their mortgage because they're allowing unrepaired conditions in the building, which is actually a breach of mortgage. Every mortgage has a clause that says that the borrower will keep the building in good condition. So if we write to the bank and say the landlord is not keeping this building in good condition, you should foreclose. That is not a breach of contract. The reason is that we're not asking the bank to breach the contract. We're not asking the bank to do anything that violates their mortgage contract. Foreclosing is actually one of the bank's rights under the contract. We're asking them to follow the contract, not violate it. And if they choose to do so, right, there's been no breach of contract. If there's been no breach of contract, there's no tortious interference with contract. Right? And we're assuming here, you know, hypothetically, if a landlord was in fact not in breach of their mortgage contract, and we wrote to a bank asking them to foreclose, and the bank did foreclose, that might be tortious interference with contract. But I think it's pretty safe to say that banks don't go around foreclosing on big landlords when they have no basis to do so just because we as tenants asked them nicely to do so. banks, before they foreclose on companies, usually make sure that they've got some legal basis to do so, right? So if a landlord truly is in default under their mortgage, and remember, they can be in default under their mortgage by failing to do repairs, not just by failing to make payments. And we ask a bank to follow the part of the mortgage contract that says the bank gets to foreclose if you're in default. Nobody's talking about any kind of breach of anything. And there's no tortious interference. Nevertheless, I've gotten several cease and desist letters from landlords' lawyers saying, you're not allowed to talk to our bank, otherwise it's tortious interference with contract. But that's an area where we should know we're safe. There really is, again, unless we're lying to the bank, we're not even in the neighborhood of tortious interference with contract. Annie asks in chat, does the contract have to be actually canceled for a claim of tortious interference? Not canceled exactly, it just has to be breached. And it's possible to breach a contract without completely canceling it, right? So if I've got a contract with you I'm going to come in and redo your kitchen and you're going to pay me for it. And I come in and I only do part of your kitchen, right? That could be a breach of contract, but not a cancellation of contract. And tortious interference applies even if it's just a partial breach of contract. But there's still some part of the contract left. It's a good question. Another area where we get cease and desist letters is when we're organizing a rent strike. And the reason is that if you're organizing a rent strike in some form or other, you're probably going to your neighbors and saying, don't pay your rent. And so on first glance, that actually looks a lot like tortious interference with contract because your neighbor has a lease. The lease says they have to pay their rent, and you're going to them and saying, violate your lease, don't pay. Right? And for that reason, we get cease and desist letters sometimes. But let's take a closer look at what's actually happening there, right? The lease might say you have to pay your rent. But the law also says that tenants don't have to pay their rent if the landlord is not doing repairs. Right? We can withhold rent. We can ultimately get a ruling from a court that says we don't even owe the rent after the repairs are done sometimes, right? So when a tenant withholds rent because they're unrepaired conditions, they're not actually breaching their lease, right? Every lease in the state of New York, even if it doesn't say so in writing, is considered to include this part of the law implicitly, right? Which is, by the way, real property law, section 235B, if you want to look it up. That's the part of our law that is the warranty of habitability and says we can withhold rent. Right? So if you're saying to somebody, exercise your right to withhold your rent until repairs are done, you're not asking them to breach a lease. You're asking them to do something they have the right to do under the lease, right? If you're worried about getting, some backlash in that situation, we've worked with organizers to kind of craft some language to be extra safe in that situation, right? So instead of just saying, stop paying your rent so we can, bring the landlord to their knees, you might want to say, we have the right to withhold rent until we get repairs under the law, and now is the time to exercise that right? To make clear that we're not just saying don't pay the rent so we can screw our landlord, but don't pay the rent because we have that right and we want to exercise it, right? Landlords are delaying repairs during the pandemic. This is language you actually put together. You may remember there were a lot of rent strikes during the pandemic, and we actually got kind of a flurry of cease and desist letters then. And so this was some of the language that tenant association used. Landlords are delaying repairs during the pandemic, and so you have the right to withhold rent for those repairs, right? Make it clear that we're withholding rent for a reason and not just, to screw our landlord over. And for what it's worth, actually, at the time of the pandemic, when there were a lot of rent strikes and there was a lot of cease and desist letters coming out, the Attorney General's office actually weighed in and put out, a statement saying that their understanding of the law under this and also under the Real Property Law 230, which is, the tenant's right to organize law, that organizing a rent strike could not be tortious interference with contract, and that if a landlord sued a tenant for organizing a rent strike, they might actually be illegally retaliating against them. I looked online when we were getting ready for this training, and unfortunately, that statement doesn't seem to be anywhere on the Attorney General's website anymore. But if this came up and we were actually getting threats from a landlord, there's a pretty good chance that we could get somebody from the Attorney General's office to, put something in writing or call up the landlord. Don't want to promise that, obviously, because we're not the Attorney General, but we know that they've been an ally on this issue in the past. So again, just like a mortgage foreclosure, withholding rent is not a breach of lease. It's you exercising one of your rights under the lease. No breach of lease, no claim for tortious interference of contract. Okay. So we're moving on to another topic here. Again, I expect people probably have questions about tortious interference. To be honest, I have a lot of questions about tortious interference with contract. But bracket those for a moment because I want to talk about New York's anti-SLAPP law, right? So New York, along with every other state in the country, actually has a law that is designed to try to discourage SLAPP suits. So going back to the beginning, remember, SLAPP stands for Strategic Lawsuit Against Public Participation, right? Which is when you bring a lawsuit against somebody basically just to shut them up. Everything we've been talking about so far tonight is how to make sure that no one will have a good legal claim against us, a legal claim that they could actually win. But the fact is, a lot of actors out there will bring lawsuits even when they know they don't have a good claim, right? Certain presidents of the United States have a habit of doing that. And I'm not saying which person who's currently president of the United States does that, but one of the people who's currently president of the United States is Exhibit A in doing this, right? So the idea there is somebody who has deep pockets, right, sues us. And it's a lawsuit that we'd win, but in the meantime, it's going to be a huge burden, and maybe we can't afford the lawyers, and maybe we can't even get all the way to the end of the case to win it, right? So in order to discourage that kind of behavior, New York has an anti-SLAPP statute. What it says is if you get sued, right, so you're a defendant, and the facts, the conduct, the behavior, the things you did that you're getting sued for involved what's called public petition and participation, right? We'll come right back in a minute to what that is. If you're getting sued for public petition and participation, then you may have a counterclaim, right? You can sue back for SLAPP. Public petition and participation used to be actually fairly narrowly defined under New York law. New York actually had one of the worst least useful SLAPP statutes in the country, because it used to only protect statements or actions that you take that are actually formally part of some kind of government process, right? So if you say something at a public hearing, city council public hearing, if you say something to 311 making a complaint about a violation to HPD, right? If you say something to your elected officials. So that was really kind of a narrow area of behavior that was protected, right? It didn't, for example, cover something that you say to a newspaper, right? Or something you say to your fellow tenants, or something you say at a rally, right? Or a letter to the editor. Fortunately, several years ago, New York amended its statute to finally bring us almost up to where most states are, with a much broader definition of public petition and participation that now includes most public statements that are aimed even indirectly to trying to get you know a policy to get enacted or the government to take action. So that's much more broad, right? So it could now cover something that you say at a rally because the thing you were saying wasn't directly aimed at the government. It wasn't only aimed at the government, but you could say that, getting the government to take action was one part of what you meant. Right? So we're a lot more protected now. The kinds of things that we can get sued, the kinds of behavior that are protected if we get sued, right? And the idea behind the SLAPP law, right, is to encourage people to participate in public life and not to feel like, listen, going out there and making public statements and participating in our democracy and organizing are things I can't afford because I don't have lawyers and I can't get sued, right? So how does the law work, right? It means that if you get sued for something you said, right, you can bring a counterclaim. A counterclaim is, in a lawsuit where the defendant sues back, right? It's like you're suing them back as part of the same lawsuit, right? And if you win your counterclaim, they might have to pay you, right? In order to win that counterclaim, right? And I should add, you don't necessarily have to bring it as a counterclaim. You could actually wait until this lawsuit is done and then sue them in a separate lawsuit. There's some flexibility there. It usually makes a lot more sense to raise it as a counterclaim in this lawsuit because, that way you'll get to make all your arguments in one place, right? And since the idea behind SLAPP suits is to run up people's legal costs, it's not usually in our interest to try to multiply lawsuits and sue on different things in different cases. So assuming you bring this back as a counterclaim, right? You get sued, you say, all right, well, I'm suing you back. Here's my counterclaim. The things you have to prove are, one, that you're being sued to prevent you from engaging in any communication in a place open to the public or public forum in connection with an issue of public interest. That sounds pretty broad, and it is pretty broad. That's the language we have since the statute was amended, right? And then in addition, any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest, or there's a lot of language here. The key thing there being lawful conduct, which is to say that if you actually did do defamation, if you actually did do the thing you're being sued for, then the lawsuit against you is not a SLAPP suit, right? It's actually a meritorious suit. And the counterclaim won't work, right? In order to win your counterclaim, you've got to show that, first of all, you win on the overall claim. You haven't done the thing wrong, right? You haven't committed any tort, right? Plus, the purpose of the lawsuit was to shut you up, because of something you said in public. If you can prove those things, you get damages and you get attorney's fees. And as an attorney, I think that's pretty cool. The idea for this is this, hopefully we don't ever have to use this. The point of the law is actually to act as a disincentive, right? To make it so that, a corporation or somebody with deep pockets will think twice before they bring a SLAPP suit against you. Because they know that if it goes south on them, they might wind up having to pay you. And our hope is that, again, the landlord's lawyers are advising them not to get too aggressive because they could get hit back, or at the very least, after they bring a lawsuit and we come in and we raise a SLAPP counterclaim, that's going to make them say, oh, okay, we'll settle, right? Right. And just so we know, statutes of limitations are obviously very important things when considering if we're at risk of something legally. It doesn't matter what you did. If you did it more than a year ago, it could be, total defamation. But if it happened more than a year before they sue, you are safe. However, often things that we say get re-said, right? So republication on the internet, right? Things that we say, we can no longer assume that they just disappear into the air. Things that we say may be part of a video that gets reposted later, right? And so sometimes things that we thought were in the past are actually happening again. And the statute of limitations might start to run again. Tortious interference, the statute of limitations is 3 years. Trespass, which we didn't talk about in tonight, but which is another kind of claim that landlords often bring, usually against tenant organizers, like the Cooper Square organizers, not against you, since you're not trespassing in your own buildings. The statute of limitations on that is 3 years. So just good to know that these things don't hang over us forever, but that when we're talking about statements, we want to be really careful about where those might have been saved or where they may come up again, in somebody's feed. All right. So I'm guessing because all of those concepts are incredibly simple concepts and tortious interference with contract is super simple, and there's no blurry lines or subjective determinations there at all. Nobody has any questions, and we can all log off and go for a drink.